Hi, everyone. Thanks for joining us for another Bronf Talk today. I'm Adam Shapiro. I'm a 2009 fellow, and we have a great conversation today. And we were sort of waiting this morning to see if there would be another decision, and if the abortion decision would come out. Instead, there's another immigration decision, which seems like it will have far-reaching consequences. So we'll get into that as well today. And if you have any questions throughout the discussion, we want to include alumni as much as possible. So whether you're a lawyer or not a lawyer, everyone is welcome to chime in. So if you have a question, you should find a participant that says questions or questions here, and just message that participant, and we'll try to bring you into the conversation as soon as we can. So without further ado, let me introduce our esteemed panelists today. Igor Timofeyev is a 91 fellow. Today, he's a partner at Paul Hastings, specializing in Supreme Court and appellate litigation. He's a former law clerk to Justice Anthony Kennedy and served as a director of immigration policy at the Department of Homeland Security in the George W. Bush administration. Hi, Igor.
Adam.
Thanks for joining us. And
thanks for having me.
Absolutely. And Allison Lauterbach-Dale is a 2000 fellow. She received her PhD in US history from USC and her law degree from UC Berkeley. Her doctoral dissertation looked at US legal, political, and social conflict surrounding abortion. She then joined Morrison Foerster, where she worked on several high-profile pro bono reproductive rights cases, including Whole Women's Health versus Hellerstedt, which we'll talk about in a bit. And she now works as privacy counsel at LinkedIn. Hi, Allison.
Hi there.
Thanks for doing this.
My pleasure.
So Igor, let's jump in with this decision we got this morning. It seems like the court ruled that asylum seekers don't have the right to challenge expedited removal from the country. So can you talk about what that means and like how much this will affect deportation proceedings going forward?
Sure, happy to. So this decision that Supreme Court issued this morning in a case named Department of Homeland Security versus Forensic Gym, and basically what expedited removal is in 1996 Congress passed a law which set up a system, amongst other things, set up a system of expedited removal where if you come into the country and you come illegally, not through a port of entry like an airport or a land-based port, and you actually, or even if you come through a port of entry, if you arrive and you claim asylum, you claim that you are seeking to escape prosecution and you're afraid to return back to your country, typically what happens is there will be an immigration officer who will conduct what's called a credible fear screening, sort of an initial review to see whether or not you in fact have that fear, whether that fear is credible. And it's not an asylum determination, it's just an initial screening. And then the law prescribed that you have, if the asylum officer concludes that you don't have a credible fear, the law prescribed that you have some limited forms of challenging it. You can challenge it before the immigration judge, and then you can also challenge it before a court, but you cannot actually see, you cannot see the relief of the habeas corpus, which typically has been used to free individuals from prison if their imprisonment was actually unconstitutional or illegal. And so there is something in the Constitution, there is something called the suspension clause, which provides that the government executive branch can only suspend the right of habeas corpus in cases of insurrection or rebellion or at wartime. And famously, President Lincoln actually used that suspension power during the Civil War. So this limitation on the habeas corpus review was challenged as being against the suspension clause. And so the Supreme Court in a 5-4 decision, kind of breaking down along what are called the traditional conservative liberal lines, rejected that claim. So in a decision written by Justice Alito, the court said, walk through the historical origins of a suspension clause and said that, look, the suspension clause only applies to writ of habeas corpus, and that writ historically has been used to essentially to get yourself out of jail if your imprisonment was illegal. And so Justice Alito said, well, that writ does not extend to claims such as this, where an alien arrives into a country, into the United States, and is trying to, in fact, obtain a judicial review of his asylum credibility, of his asylum claim. So so on that basis, the majority of the court said that you cannot challenge, you cannot in fact challenge that initial determination that found you have no credible fear of persecution. So I think the decision is significant because expedited removal is used quite a lot in order to remove people who are coming into the US and who are apprehended, either they arrive actually and openly present them at the border, or they actually apprehended trying to cross the border illegally. So, so if the court had gone the other way, it would have enabled these individuals to then have a much more robust access to judicial process and to challenge these, to challenge their removal decisions or the basis for the removal decisions. So in that sense, it, you know, it will, this decision kind of continues the status quo and continues and allows the government to remove these people through a more expedited process that has been used for the Bush administration, for the Obama administration, now for the Trump administration. So there were two dissents actually from the decision. There was one dissent, there was actually one dissent and there was one concurrence in the result only. So concurrence in result only was written by Justice Breyer and joined by Justice Ginsburg. And those two justices said, we agree with the outcome in this particular case. This particular type of request is not something that is subject to a habeas corpus review, and so constitutional protections of the suspension clause do not apply. But they said they wouldn't generalize it to other types of claims that may be presented, say, by an immigrant who's already been entered into the country legally, but has already been in the US for a number of years. And then there was a dissent, which was written by Justice Sotomayor, joined by Justice Kagan, which took a different approach and argued that in fact, there was a violation of the suspension clause because this is a type of claim that should be reviewable on habeas corpus.
That's great. And so to put it into slightly just concrete terms, my understanding is that as much as expedited removal has, as you're saying, I think has been in place since Clinton or Bush, it's been in use much more in the Trump administration. They've been making greater use of it. I don't know if that's if I have that right, but with this decision, basically, once a customs officer decides that somebody doesn't go through the asylum process, there's nothing more they can do. They'll be basically removed from the country, and it's up to every individual sort of customs officer. Is that along the lines of sort of some of the implications of what this will mean?
So I think the way that the way the process works is for instance, when you arrive at the airport coming from abroad, you're usually interviewed by you're right, an officer of the Customs and Border Protection. And so he'll screen your passport, look at your record, may ask you why exactly you were abroad, what you did there, how long you've stayed abroad. But mainly he is looking to see through your immigration history, actually through a history of entry into the country. And that customs officer, if you then tell him that, look, you actually intend to apply for asylum in the US, he himself will not make the asylum determination. He will send you to a trained asylum and refugee officer who are trained in making sure in determining whether or not a person claiming asylum in fact has a legitimate claim. But the difference in expedited removal is that asylum officer will only perform a kind of preliminary screening. And if he determines that the person doesn't even meet preliminary standard, then essentially you will be sent back and you have very limited ways of challenging it. So it's not going to be the same type of examination that you typically undergo if you apply for asylum within the United States or with the asylum officer before the immigration court, because in those situations you can actually present evidence. You typically have an attorney. You have much more robust ways of appealing. So it's a much speedier system for making these determinations regarding asylum claims.
Right, and that could otherwise have been a 2-year process, and now it'll be sort of like almost immediate. It sounds like. But to move on to the DACA case, which is also an important decision that we got last week. Actually, before we get to the ruling itself, it might be helpful to sort of back up and explain sort of some of the history behind DACA and why Obama put DACA into place and sort of the Trump administration's attempt to rescind it. Can you kind of give us some of that context?
Sure. And the history, I mean, the history of DACA stretches now about, I guess, about 8 years back. So President Obama, first of all, President Obama instituted DACA, which is called Deferred Action for Childhood Arrivals, in 2012. And the reason he did that, before that, there were numerous attempts in Congress going back to the early 2000s to actually pass some kind of immigration reform. And as part of that immigration reform, to provide people who came here illegally but as children and who then went to school, graduated, were able to get employment, sometimes served in the military, essentially to provide them a path to stay legally in the country and also to get green cards and eventually become citizens. These efforts, and I worked on some of them when I was in the government, these efforts ultimately failed in Congress. So President Obama enacted DACA, which was through an executive authority. And DACA essentially provided, the Secretary of Homeland Security issued a memorandum saying that for certain class of individuals, those who arrived in the US by a certain date, who were of a certain young age when they came in, who were then no older than 30 or 31 at the time of this memo in 2012, and who went to school, were still going to school, or have graduated, have not committed any crimes. So those individuals, first of all, the immigration officers will not try to arrest them or deport them. And secondly, they were also given something which was called a legal presence, which means that the administration allowed them temporarily to stay in the country legally. And so they could get work authorizations, they became eligible for a range of benefits. And the program, the DACA program, what's interesting, it's been fairly popular when it was enacted. It is still, even today, remains, commands quite substantial broad political support across the spectrum, because I think everyone realizes this is, these are very deserving kids, or now deserving individuals, and so the program actually has, when it was instituted by President Obama, there were really no significant legal challenges at the time. What happened later on, 2 years later, the Obama administration tried to expand the program by, for instance, removing the age cap, but also they created a new program which was for parents of kids who arrived in the U.S. illegally, but then who obtained green cards or even citizenship. And the DACA program by itself probably reaches about 800,000 people. The separate program for the parents, potentially would have reached over 4 million people. And that program was challenged by about 25 or 26 states, who challenged it as both on procedural grounds under the administrative law, but also as illegal under the immigration law. The main argument was the Secretary of Homeland Security actually did not have authority to promulgate that program. And that challenge then went through the courts and went to the Fifth Circuit Court of Appeals, which sits in the territory of Texas, Louisiana, some of the other sovereign states. In a divided decision, that court actually held that the program was in fact illegal, specifically that the right that the government granted to the parents to obtain legal authorization and be able to become eligible for benefits, that was something for which there was no base in the Immigration Act. But the Fifth Circuit did not touch, even though it invalidated the extension of the program for the children. It didn't actually invalidate the DACA itself, because that was not challenged at the time. And then what happened is, in 2017, the Trump administration first formally rescinded the program for the parents, which by then has been stayed by through a court order anyway. But it also then, the Attorney General, Jeff Sessions, who was Attorney General at the time, issued a memorandum saying that, in his legal opinion, the DACA itself, the program for the kids, was also illegal under the immigration law. And in response to that memorandum, the next day, the acting Secretary of Homeland Security, Elaine Duke, issued a memorandum saying that based on the Attorney General's view that the program was illegal, she was rescinding DACA as well. But she essentially she enacted several provisions to wind down the program. So for instance, kids who already had work authorization were able to maintain it for a certain period of time. DHS would still accept some applications for renewal for a certain period of time. So the idea was that the program would not be terminated immediately, so as not to make these all these kids suddenly illegal, and also to provide a way for Congress to potentially address it through legislation. So the decision to terminate DACA was then challenged in courts, and this legislation eventually came up to the Supreme Court. So, so the question before the Supreme Court was whether or not the Secretary of Homeland Security's decision to rescind DACA was, first of all, whether courts could actually review that decision, but secondly, whether or not that decision violated the requirements of the administrative law.
And so, why was it ultimately? What did the court find? If it was passed by executive order, why couldn't it be rescinded through DHS or the executive? What did the court find?
So the court actually did something which I think quite interesting, and this is the court divided 5-4 on this issue, but kind of in a different went in a different direction than it did in the case involving expedited removal. So here, the Chief Justice Roberts, who wrote the decision, was joined by 4 traditionally more liberal justices, and he issued what is a fairly narrow opinion. So so the court majority held that even though DHS, Department of Homeland Security, had authority to terminate the program because, Adam, as you said, it was created through an executive measure, so it could be terminated through an executive measure. But they had to go through the procedures, of the administrative law. And there is a statute that's called the Administrative Procedure Act, which imposes certain requirements on how government agencies have to make their decisions. And they, amongst those requirements is that their decisions cannot be arbitrary and capricious. And it's a fairly malleable standard, but over the years or decades, the Supreme Court and other courts have elaborated on what that standard means. And importantly for this case, one of the requirements is that when a government agency makes a decision, it has to consider appropriately the available alternatives. It has to provide an explanation for its decision, and especially when it changes course. And so Chief Justice Roberts here said that even though it was acknowledged that DHS could terminate the program, it did not actually consider appropriately all the available alternatives. So, and the main focus of the opinion was the court said, look, the basis for the rescission of DACA was the Attorney General's conclusion that the program was illegal. The program lacked the legal focus. But the court said that really relates to the decision that to grant the kids under DACA the legal presence and to allow them to stay in the country legally and also to gain access to benefits. The other part of DACA was that the decision that the immigration authorities will not try to actually arrest and remove and deport those kids. And the court said, well, the Department of Homeland Security rescinded both parts of the program, even though the Attorney General did not say the rescission that the exercise of this prosecutorial authority or decision not to exercise it was also illegal. And so the court said the agency has to actually go back and decide whether or not it was compelled not just to rescind the eligibility for benefits, but also whether it was compelled to rescind its decision not to deport those kids. So it was a fairly narrow opinion in that sense, and it kind of theoretically it left open the possibility that the Department of Homeland Security could still try to go through the motions and come up with a better justification. But it also being issued in the, obviously in the election year, it also probably ensured that you will not see any action like that, at least until after November or January.
I think it's interesting because in some ways, at least there's some people who would like to see this as a ruling against the Trump administration, which I guess it certainly is. But it's, as we just saw in the case today, there's the court isn't looking to necessarily reduce executive authority. They're certainly happy to see, as at least in immigration, to allow the authority of the executive authority. And it looks like in this case, it was really just an administrative question, a question of, Justice Roberts' background in administrative law, wanting them to do it properly. So if Trump is elected and they want to try to rescind DACA again, briefly, what would you say? How likely would it be that the Trump administration would be able to do that, or what would they need to keep in mind?
So, Adam, I think you're absolutely right. It's interesting that this decision, in part, I think it is explained by Chief Justice Roberts' background in administrative law, and I think as a small c conservative, my guess is he's probably quite happy to actually put more barriers or more requirements on the agencies in terms of being able to make executive decisions, so to enact regulations. I think it also shows that Chief Justice Roberts is often someone who is incrementalist. So he often prefers to make a decision that is fairly narrow, and it sort of preserves the status quo to a significant extent, and then leave the greater question of what can be the limitations on executive power for another day. And I think this one certainly shows where, in a way, the court under his leadership reaffirms the notion that the president has broad discretion in immigration, but it imposes these procedural hurdles on the president or on the Department of Homeland Security under his direction to actually exercise that broad authority. But I think there is, so, let's say for President Trump gets reelected and, decides to rescind DACA again, he will have to go through those, all that reasoning and see if the Department of Homeland Security can come up with a justification that will stand up to judicial scrutiny. And the Chief Justice Roberts saying, I'm not expressing an opinion whether or not you can actually do it, but here are some additional factors you probably have to consider. But I think there is also another side to it, which is a political side, and you see it in actually some of the dissents. You saw it in the main dissent by Justice Thomas. You saw it in a separate dissent by Justice Kavanaugh, where they're saying, look, this is really a question that belongs in the political branches. It's politically sensitive issue. And Justice Kavanaugh in particular said, these are very deserving individuals. And so I think what you may see if President Trump gets reelected is some kind of effort to resolve this issue through a legislative process, perhaps for some kind of a legislative compromise where the program that would legalize these kids and provide them with a path to citizenship will be coupled with some sort of immigration enforcement measures if there is a second term for President Trump, the Trump administration would probably want.
Yeah, it would obviously certainly put them on more secure footing, and to some degree, hopefully we'll see if there's a bipartisan appetite to do that. And I hope we can get a little bit more into the sort of this new composition of the court, Igor. But that was really helpful. And so these were sort of the big immigration cases we saw before the court. And one of the big cases outstanding that we're waiting for a decision on is June Medical Services, this big abortion case that's before the court. And so, Allison, I'm wondering if one of the interesting things about June Medical is that it's very similar to Whole Women's Health, which is a case you worked on. So why is this case basically before the court again?
So, good question, and hi, everyone. Why is it before the court again? Well, I don't know that any two lawyers would agree on the answer to that, but what I would say is that when it's come up before the court, part of the question is whether the Whole Women's Health ruling actually is a fact-based inquiry. So in Whole Women's Health, there were a variety of anti-abortion, well, depending on what your politics are, how you would describe it. There are a variety of measures put in place to restrict abortion clinics, including, among other things, admitting privileges for doctors. So doctors had to have admitting privileges within a certain proximity to a hospital in order to keep providing abortion services. That, as well as a bunch of other restrictions, were found to place an undue burden on women seeking abortions. Before the court now is again the admitting privileges, the question of admitting privileges. They need to have, doctors in Louisiana have to have admitting privileges within 30 miles of the clinic. And part of the issue is, well, if this is already decided, why is that not binding precedent? And that is one question for the court. Is this binding for all abortion laws passed here forward, or is that a fact-specific inquiry? Was that decision based entirely on the geography of Texas, where the clinics were? The mileage restriction is 30 miles, okay? What about 50? What about 5? So I think that that is probably where there's wiggle room as to whether or not SCOTUS decides to uphold the Whole Women's Health as binding precedent, or if they want to find a reason to kind of allow these laws to go into effect. I do want to say, just as context for the fact that this is an election year, and I'd be curious what Igor says about just, especially having worked for Kennedy in the Supreme Court, abortion is extremely polarizing. That's like the understatement of the year. And before everybody else got admitted on, or got admitted into the Zoom, we were talking beforehand that part of me wonders if the Supreme Court wouldn't want to just punt this question to after an election. When I worked at Morrison and Foerster, there was a partner there who had clerked, I think in the early 50s, and he was actually, he had clerked the year before Brown v. Board came down, and he told us that the justices deliberately opted to delay hearing that case because they didn't want to issue a ruling on school segregation during an election year. And so the fact that this is, if you're a constitutional lawyer or either a pro-life or a pro-choice advocate, you may be following these nuanced questions of why is Whole Women's Health not binding, or is it binding? Is it a factual question or one of law? But the reality is that however the court decides, it's going to be viewed either as, limiting abortion or advancing abortion, or, pro-choice or pro-life. So even if there are those nuances, the fact that this is coming down 6 months or 5 months before, fewer than that, 4 months, I think, before an election, I'll say it's interesting to say the least. Part of me wonders if, and again, this is all tea leaves, because you can, there are all these articles saying, well, so-and-so asked X amount of questions during oral arguments, and so-and-so didn't even address this. So we really have no idea. Kennedy was the swing vote for Whole Women's Health. He's gone now. Roberts, by all accounts, is an institutionalist, and I do think he'd want to uphold the value of stare decisis, that Supreme Court precedent is binding. But so the question that you started off with is the most complicated question, although with abortion, they're all complicated questions, I suppose. So I'm just going to punt and say we don't know. And we'll for the Supreme Court to decide.
And we'll find out, in very short order. But I think that is the fascinating question of sort of how the composition of the court is changing things. And so hopefully we can circle back to that soon. But I do want to spend time. So at issue in this case are these Louisiana laws that are. Can you explain how they're purported to be in the interest of women and what their actual sort of effect is?
So the idea is, for those advocating for the laws, that they are there to protect women, that by requiring doctors to have admitting privileges to hospitals, that abortion providers have to have admitting privileges to a hospital within 30 miles of the clinic, it would ensure continuity of care should there be a complication during the procedure. That's what they say on its face. In reality, abortion has one of the lowest complication rates. I know in Whole Women's Health, I believe Justice Kagan during oral arguments went through the complication rates of other procedures, and I think colonoscopies had higher rates of complications compared to abortion. So A, abortion is actually extremely safe, and B, when there are complications, it's more often the case that they happen once women have returned home, which, given how few abortion providers there are in places like Texas and Louisiana, there are only 3 in all of Louisiana currently, the likelihood that women will be within 30 miles of their hospital is very much up for debate. And if, God forbid, a woman undergoes or experiences complications at a clinic and they have to go to a hospital, whether or not her doctor who is doing the abortion has privileges is not going to preclude her from getting health care at the hospital. So there's very little correlation between, from a medical and statistical perspective, between a 30-mile radius. And Justice Ginsburg said, why 30 miles? Why not 40 miles? Why not 5 miles? It seems kind of arbitrary and not directly tied to protecting women, which is the argument for a lot of these laws. So yeah, that's the answer to that question.
That's helpful. And if, by the way, if anybody listening wants to jump in with a question, there's a participant labeled questions, and you can just sort of briefly write your question. We'll try to go to you. So the other issue, the other issue is the issue of standing in the case, and sort of the question of whether a healthcare provider or doctors can bring the case on behalf of their patients. Can you talk a little bit more about that?
Sure. So for all of you on the call who did not go to law school, the idea of standing is that you need to have, basically, this is a very shorthand way of saying, you have to have a vested interest in the case. You have to be directly impacted in order to have the right to sue. In the case, and it also has to be, my civil procedure professor would be very disappointed at how I'm describing this. So Igor, feel free to jump in at any time. But it has to be timely, so the case has to actually affect something that is an ongoing harm, and you have to have standing. You have to be directly impacted, essentially. So the argument here is that, or the argument for them not having standing, is that doctors should not be allowed to argue on behalf of their patients, because they're saying that it's a woman's right and it would to an abortion, and that it would place an undue burden on the woman. However, doctors are the ones actually being regulated by this. So the impact of the regulations would affect women. But if a doctor is providing abortions or is no longer able to provide abortions because of these laws going into effect, then they would be directly impacted. From a procedural perspective, I'd point out that Louisiana did not actually raise standing as an objection until they got to the Supreme Court. So if you don't raise it at the trial level, you basically waive the argument. So that's one rebuff to the issue of standing, and that they didn't raise it in time. I think it was Justice Ginsburg in oral argument said, well, had they raised it earlier, they could have added women plaintiffs. The other issue, well, two more things. One is that there have been other examples of doctors suing on behalf of their patients on the issue of abortion. I think Breyer cited 8 different cases. And finally, women, like I said, abortion's complicated. Women don't necessarily want their name attached to a case as a plaintiff. From a timeliness perspective, given how long litigation lasts and how long it takes to resolution, the chances of a woman plaintiff wanting an abortion and then getting the result of a case within, the 40 weeks that she's pregnant, is slim to none. I have a lot of, quote, fun facts about abortion from all my historical research, and I would point out now that Jane Roe actually had the baby because Roe v. Wade was not decided in time for the pregnancy. And actually, pregnancy and abortion it's a small loophole where the timeliness issue could actually be waived because of the nature of pregnancy lasting a while. So I've talked enough that I've actually forgotten the question.
No, it's important too, because it makes it it's understandable that it's hard for patients to have standing if their pregnancy lasts 9 months and court proceedings take as long as they do. Right. I wonder if this is Herschel has a question about how admitting privileges work in practice. So Herschel, do you want to jump in with that?
So, I've been following this. Obviously, we follow this up here too in Canada. We don't actually have an abortion law in Canada. It was struck down in the 1980s. This is for context. And governments since then have decided not to put in a new abortion law. And so it's now abortion or termination of pregnancy is now a medical procedure and governed by clinical rules. Like, for instance, I can't do abortions because I'm not trained to do abortions, so I don't have to worry about abortions. So my understanding is that part of the issue around the law is that you have to have privileges at the hospital that is near your clinic in order to provide abortions, and that one of the concerns is that one of the ways to limit access to abortions is to not grant privileges to providers who will do abortions, thereby saying you can't have privileges here so that you can't do abortions. Is that correct?
Yes. Also, I feel the need as an alum. This is happy 20th to any 2000 alumni here. Herschel, you're like a Bronfman celebrity on the listserv, so it's so exciting to actually see you in person, so it's an honor. Just had to throw that in there. Yes, so it's an excellent point. The admitting privileges are part of a series of laws. They're called trap laws, and they essentially try to chip away at abortion access without overturning Roe. I'd point out that Justice Alito was actually among the, he was part of the group of conservative, big C, little c, attorneys in the 80s that really, rather than overturn Roe, the idea was, or the strategy was, let's chip away at access. So instead of saying abortion is no longer legal, we're going to do things like have a 72-hour waiting period from the time you get to the clinic to when you can actually have it. We're going to force women to undergo very physically invasive ultrasounds before they can sign off, and so forth and so on. So the admitting privileges is an example of one of those ways that they would chip away. So to put it in numbers, in Texas, when the rules were put in place, and granted that law also had to do with things like requiring abortion clinics to be up to hospital code. So if a clinic didn't have closets that there were the right measurements as required under a hospital, they would have to close, things like that. So it's not a one-to-one comparison, but in Texas, when the law was in place for about 2.5 years, the number of clinics in all of Texas went from 41 to 22, largely in part because hospitals don't want to give abortion providers privileges, especially in the South, where there are a lot of Catholic hospitals. They don't want to give doctors who provide abortions privileges. I'd also point out that a lot of the abortion providers, the doctors who practice in those family planning clinics or in the abortion clinics, haven't had to work in a hospital in years, right? Because of the low rate of complications, they're seldom in a hospital in a professional capacity. So with fewer clinics, there are going to be longer delays. You're going to reduce access. Women are not going to be able to get to a clinic because the clinic closest to them closed. In the case of, there was a law passed in Alabama in 2014, and the court blocked its enforcement because none of the providers in Birmingham, Mobile, or Montgomery would be able to obtain privileges. And so no physician with privileges could start providing abortion care. So that would leave only 2 clinics in the entire state. Mississippi has 1 clinic in the entire state. And so, in the case of Louisiana, they have 3 clinics. And if this law is upheld, they would all close. One of the doctors, so at the time that the case was filed, I believe there were 2 providers who had admitting privileges, even though there were 3 clinics open. One of them has since stopped providing abortions, and the other one is about to retire. So if the admitting privileges are required, those 3 clinics will close, and there will be no longer, it'll be the first state where there is no abortion clinic. And that doesn't just affect Louisiana, it affects the parts of East Texas and Arkansas and Mississippi and Oklahoma where patients are coming from, because those are the closest clinics. So you're absolutely on point that this is not just a matter of admitting privileges. This is about whether or not women will actually have access to get an abortion at all.
So I think it's interesting to contrast that, here in Canada, there are differences in Canada. Like, for instance, one province didn't even have an abortion clinic for a very long time. The federal government actually is providing assistance to provide access. Most abortions in Canada are covered by public health insurance, and so you don't even have to pay for an abortion in Canada. And access is not based on the ability to pay. Now, there are other issues around access. We have vast areas in Canada that are sparsely populated, and that might be an issue in terms of access there. But it's a very different landscape.
So I have a fabulous doctoral dissertation that you're welcome to read that touches on exactly that. Because the United States, when Roe was decided in '73, it was part of this global decriminalization of abortion. And in places like Canada or the UK, for instance, abortion is not the controversial topic that it is in the United States. And a lot of that has to do with the rise of the religious right and the grassroots effort around basically making abortion into not a medical issue, but into one, even for many it is, right? So there are those who actually, you know, and I'm not here to judge or debate whether you are pro-life or pro-choice, but it was definitely a politically galvanizing issue. And I know that we still have other things to talk about, but what I will point out is that abortion was legal at the time of the nation's founding. Abortion was legal up until the time of quickening, which is typically around in the second trimester when a woman can actually feel the fetus move. It was made illegal in an effort to professionalize the medical community. They were trying to get rid of midwives and quacks, so non-white male doctors. And it's also at the time that there was a massive influx of Catholic immigrants from places like Ireland. And so white Protestant men wanted to make sure that their women would keep having large families. And so by criminalizing abortion, that was one way to do it. When abortion was decriminalized, the evangelical community, which is now one of the most well-known pro-life, you know, political groups, evangelicals were actually in favor of abortion staying legal. They didn't want their daughters to have an abortion, but they didn't care if your daughter had an abortion. And it was only once abortion became wedded to the rise of feminism and the Equal Rights Amendment that it really kind of helped realign the country. And Pat Buchanan was a big part of that. And that's a whole chapter in my dissertation, should you ever want to read it. You and 5 other people in the world.
Send it to me.
That's fascinating context. I think there's another question we'll go to. Daniel wants to jump in with a question.
Hey everybody, thanks so much for hosting this call. I forgive any like awkward phrasing of this question, not a lawyer here, but I know that no justices would like to admit that they're not upholding precedent, but let's say like in a world where the upcoming abortion decision rules upholds these restrictions. I'm curious if you guys have any thoughts about like what that might mean long-term for stare decisis and precedent. Like I know recently in the gay rights employment case that there was a big debate over like what textualism looks like as an interpretive method and who had like the mantle for that. And I know that Kagan, for example, supposedly has been trading votes on some cases this term to like uphold precedent, even if it hasn't led to liberal outcomes. I'm just curious if you have any thoughts about what that might mean as like a longer term impact from this case.
Sure, I think it's a great question. I think if this weren't, I really wonder to what extent the fact that this is an election year will influence that. I think that there may be more wiggle room were there not about to be a presidential election. And as I said before, you know, I do think that there is room for them to poke holes in why whole women's health doesn't apply. But I think from the reality is it would shut down abortion in Louisiana. It would be a major blow to the reproductive rights effort. But I'd also point out that the majority of America wants Roe to be upheld. And I think that maybe they don't think about, that's why this method, this strategy of chipping away and doing it on a state-by-state basis instead of on a federal level has been so effective. So I think from a legal standard, you know, from a lawyer's perspective, yeah, I do think that there is room for them to say, we're not actually overturning precedent. You know, it's a factual question, not a legal one. But I think as far as like for those of you who are not lawyers, that may be lost in how this is actually internalized and felt. So I'd be curious what, Igor, you think about that, particularly since you clerked for the Supreme Court swing vote.
Well, I
I mean, I think, Daniel, I think first of all, I agree. I think it's a great question. I think, Allison, I agree with you. I'll go on a limb and say that the justices are not going to overrule the whole women's health, even though if you, obviously when that was decided, you're right, Justice Kennedy was still on the court and was a swing vote in that case. Now you have, he's been replaced by Justice Kavanaugh, so you have a different composition. But my sense from the argument and the fact that actually the court, 5 justices, including Chief Justice Roberts, voted to stay the law while they're deciding the case, I don't think they will really want to overturn the precedent openly. But you're quite right that aside from overturning the precedent, there is a way that a court can distinguish it, it can narrow it, it can actually say that, look, the inquiry has to be very case specific. And so that allows for the precedent to remain on the books, but for the outcome to actually vary in each specific case. And so I think my sense is a little bit similar to yours. I think this will be a fairly incremental decision. They'll probably, I don't know if to what extent they will just try to punt the question, because I think one way that they could maybe do it, and you saw it a little bit in Justice Kavanaugh's dissent from the state decision, to stay the law, where he said, look, we just don't yet have the record. We don't know whether or not providers will be able to get these admitting privileges. It's just too early for us to even decide. I think that they will probably reach some kind of a decision. I honestly don't know which way the court is going to go, partially because it takes only 4 votes out of a 9 justices to decide to hear a case, but it takes 5 votes to stay law while they hear the case, while they decide. And the fact that there were 5 votes to in fact put this law on ice suggests to me that not just the 4 liberal justices, but also Chief Justice Roberts had misgivings as to whether or not that law is really kosher under the precedent. So I think we'll probably see something fairly incremental. Which way it doesn't go, I don't quite know. But I also agree with you that even if the broader precedent remains in the book and the court just says, look, this inquiry can come out differently in the case of Louisiana than it did in the case of Texas, the practical implications may end up making that decision very, very different, because it would actually mean that it's much more difficult to obtain abortion in a particular state.
I do think one possible result, like you were saying, is that they could send it back to the trial court, to the district court, to develop more of a record and to actually see, well, if you've actually tried to pursue admitting privileges, how many of you are getting them, and so on. The record, the evidentiary record on that issue for whole women's health was extensive. And the law had already been in effect for a couple of years, so they know how many clinics closed or couldn't stay in operation. I do think that Roberts is an institutionalist and wants to uphold the integrity of the court and wants to protect the court. I believe that. And so I do think that it could be that he ends up saying, well, no, stare decisis does apply, without actually ruling on, without actually, deciding one way or the other on abortion itself, even if that's not how it's spun in the media. But I think you're right. I don't think it's going to be an up and down, you can do these things or you can't do these things. I do think it's going to be a little bit more nuanced. So especially, again, it's an election year, which this is not happening in a vacuum.
And I think just to add something, Allison, I think in addition to the election year, it's, my sense is this is the court that probably, for the last maybe decade, I mean, you're right, they will take abortion cases partially. They have to, if there is a particularly restrictive law, if there is a frontal attack on Roe versus Wade. But I think, this is a court that doesn't really want to reconsider that question. I mean, reconsider Roe versus Wade itself. I think the justices, certainly there are some members of the court who strongly believe Roe versus Wade and Casey were wrongly decided. But I think a lot of even conservative justices are really not rushing into that breach. And so I think that also suggests to me that we may see something where, you're right, the court kind of maybe tweaks the restrictions or sort of, toys with the margins of the restrictions, but essentially just kind of sends the case back and then waits for it to come back if it even proves necessary.
So we'll do a sort of a last call for questions if anyone wants to get in a question for Allison or Igor. Igor, I'm wondering if you can, and it was interesting what Daniel was saying about sort of trading votes. So I'm wondering if you can kind of shed some insight onto how the politics inside the, so actually both, how politics in general, zooming out from abortion specifically, affect decisions and what internal politics of the court we know about.
Well, I think the good thing, I certainly think it's a good thing, is the justices amongst few people today who have a job for life as long as they want it, which really does, for them and actually for all the federal judges in the U.S., I think it does insulate them significantly from the political winds. And I think, I think you see it, quite often the conservative justices will actually side with decisions that, the nationalists vehemently disagree with. You see also liberal justices, particularly like Justice, Brian Kagan, who side with the more conservative positions. So I think, the justices are probably not thinking about politics as such, like electoral politics. My sense is as much. I think, what they're thinking about is, as Allison said, the role of a court as an institution, the public acceptance of a court's decisions. For instance, many of the justices, and certainly that was the case for Justice Kennedy, who, if he felt the role would dictate a particular result, he'll go with a 5-4 decision, but he would much have preferred, if he were writing an opinion, to have it be a 6-3 decision, a 7-2 decision, an 8-1 decision, because the kind of unanimity behind the decision suggests that there is a greater consensus that this was the right outcome. So I think the justices are thinking about that, and I think they're also thinking quite often, many of them, about the practical consequences of the decisions. That's why I think you often see Chief Justice Roberts kind of being an incrementalist. Even when he thinks there is a particularly legal outcome, he would be willing to at least initially decide it on a narrow basis and then see how the law progresses. I think side justices as Justice Breyer, Justice Kagan, I think often kind of take the pragmatism into their judicial calculus. So I think that's, there are, and I'm not suggesting that these considerations will leave a justice, side with actually something that they think is an absolutely wrong outcome, but I think they quite often, would influence maybe not even so much the decision that is made, but the way in which it is made, whether it's a very broad opinion or whether it's a more narrow opinion. And I think in this morning's immigration case, we saw it where Justice Alito, who tends to write the broader opinions, reached the same outcome as Justices Breyer and Ginsburg, who would have still gone to the same decision, but would have done it on a much more narrow basis. In terms of trading votes, it's the court really doesn't function the way that when I was in law school, there were actually in the wake of the West Wing and its popularity, there were a couple of shows about the Supreme Court, and they both fizzled within a year because it's just the court doesn't operate with the same sort of political horse trading. But I think what happens is the justices would quite often talk to each other, either directly, or what often actually happens, they will talk through their clerks. So they'll say, hey, go and see, go talk to your friend in the Scalia chambers or in the Souter chambers and see, what Justice Scalia or Justice Souter thinks. And I would go and ask them. And sometimes I would already know. So I think the justices kind of like tend to basically get each other's temperature and see, which way their colleagues may go, and whether or not there is some kind of a middle ground that would get a more unanimous decision. What's interesting is also the justices often kind of talk to each other during arguments, even though they're obviously not addressing each other that way. But in the questions they ask of advocates, you see that they are trying to get a sense of which way their colleagues are leaning, or maybe propose arguments that would appeal to some of their colleagues. And it's interesting, it's going to be interesting to see to what extent the fact that the court had to do arguments by phone in the last 2 months of its sitting, to what extent that's actually going to limit, that, and just, not being in the same building is going to kind of like limit, the ability to do this informal communication.
That is interesting. Yeah, no, that's fascinating. And I guess I wonder if, I don't know, I was thinking when you were talking, maybe instead of trying to do a drama about the Supreme Court, if they did like a buddy comedy with, with Justice Ginsburg and Scalia, that would have been more successful.
There is actually an opera which is called Scalia Ginsburg.
That's right. Yeah. I heard about that.
I
did you want to jump in,
just,
Allison?
Yeah, just briefly. And I think my dog is about to run in the background, so just to be warned. On the issue of how insulated they are or not from politics and cultural changes, there was a lot written about at the time of the gay marriage case, that there were a lot of former clerks that approached the justices to, come out, because they were trying to, there was an effort to personalize the case. And I know that I know that happened in particular with Kennedy, who then ended up authoring the majority opinion in the gay marriage case. And I was at a panel once, or at a symposium once, where there was a big discussion on leading up to whole women's health. So this was before it actually even went to the Supreme Court. I was still in law school, and there were lawyers and advocates, and they were talking about how there's an increased effort to personalize the abortion conversation. So people basically coming out saying, I've had an abortion. And in whole women's health in particular, there was an amicus brief of, I want to say, upwards of over 300 women in the legal profession writing and saying, look, I had an abortion and therefore I'm able to do this job and I'm able to have this life. So kind of taking it out of the shadows. And what was interesting about that symposium is that there was one of the people on the panel, is a law professor, had been clerking for Kennedy at the time of Planned Parenthood v. Casey, which established the undue burden standard. And he said at the time, there wasn't even, and if you read the decision too, you'll see there was no conversation about how this would affect women moving forward, or there were no advocates coming out and saying, I've had an abortion, this would be bad. But there were advocates on the other end. I've had an abortion, it was awful, I wish I hadn't. So I do think that that's one way, that going also to what you were saying about the clerks, it's one way that has been an effort, particularly with abortion rights advocates, to kind of personalize the movement and put a face to something that is often kept in the shadows. I would point out that about a quarter of women in the United States will have had an abortion by the time they're in their 40s. So, but people don't talk about it, right? So,
and it's like, and that's fascinating and important, because I think we tend to often think about, the work of the court as something so elevated that it doesn't really affect real people, and so just sort of this, and so putting a face to these issues, it has to affect the justices, and so that's really helpful. And I know in the DACA case as well, there was this time working on the team was a DACA recipient, and so those stories, I think they do, hopefully they do ultimately matter. So I think that was just a really, really fascinating discussion. And Allison and Igor, I'm very grateful to both of you for all your insight and expertise today. So we're going to wrap up. The one thing I'll do before we say goodbye, we have a little survey that we're going to just message publicly into the group. So we'll do that now. And I'm stalling a little bit so everyone can click on it. So that way when we say goodbye, you can fill out a little bit of survey and let us know what you thought. So again, Allison, Igor, thank you so much. And
thank you for putting this together. This was a pleasure.
Thanks very much, Adam.
Thanks.
I should say I was not speaking on behalf of my employer. I was here as myself. And
absolutely. Thanks for clarifying. All right. Thanks, everybody. Bye.
Thank you.